Okay, let's get started. Welcome to the Minnesota webinar, SCORE webinar, how to get back what your business is owed. A pretty important topic for most business owners. And before I turn it over to Michael, just a few things I want to go over for, I'm already getting questions on this. Everyone will receive a recorded copy of what you see the video. You'll get the video and the slides later this afternoon. They will also be posted on our YouTube channel probably later this afternoon or tomorrow. So you all will receive that. And I'm going to get questions on that. Please type your questions, and I know you're going to have a lot of them, into Q&A, not chat. So if you please put them in Q&A, and we will get to them when Michael's done. I will read them off and answer them, and stay on as long as we need to answer your questions. So with that, good afternoon. My name is Doug DiVirgilio. I'm a SCORE mentor in Minnesota, also a member of the Education Committee. And we welcome you to another one of our great weekly webinars. We're going to just review some basics about SCORE for you, and then we're going to turn it over to Michael in a minute and let him go through his presentation. So let me just do that. So what is SCORE? SCORE is a nationwide associated affiliate with the Small Business Administration. We work closely with them. We have 10,000 mentors nationally and over 300 chapters. Right here in Minnesota and Sarasota County, we have 90 volunteers. I can tell you highly skilled business executives and professionals from every business, both entrepreneurial and from the corporate world, to assist you as a mentor and answer any questions and be a resource for you. Our chapter has recently been recognized as a district chapter of the year, and we were founded in 1964. How can we help you? Many different ways. A lot of people have questions on pre-startup. How do I start a business? I don't know. How do I incorporate in Florida? What kind of incorporation should I do? LLC, et cetera. A lot of research and planning. The startup phase itself can be very complicated. Being in business, believe it or not, high growth can be difficult to manage. Or buying a business, selling or closing, exiting. We have expertise in all of those, and we can assign a mentor. Again, all of this is free to you. There's no charge to you. We're volunteering our time to give back. So just some of the ways we can help you, and I highly encourage you to have or request a SCORE mentor, and here's how you do that. You can go to visit score.org/Minnesota and request a mentor. The profiles are out there for you to view, or one can be assigned to you. You can also see our workshop calendar, our recorded webinars. I encourage you to look at the website. A lot of free information, great resources, business planning, and every other topic like this topic. So please take a look and do request a mentor. We have to thank our sponsors. We wouldn't be here if we didn't have them. Here's a list of them. As you notice, many are financial. And if you're working with a SCORE mentor, I think there's a helpful in to those organizations. A lot of people looking for capital these days. So another reason to engage a SCORE mentor. Now with that, let me turn it over to Michael. I'm going to stop my screen share and have him put his slides up. So just give us a minute to do that.
Thanks, Doug. Can you hear me?
Yes, it looks good.
Oh, great. I appreciate you tossing it over, and thank you, Diane, for setting this up. My name is Michael Egenthal. I'm presenting on a topic called reducing leakage, how to get back what your business is owed. I'm a lawyer, I'm a law professor, and I'm a founder of a company called Squabble, which is a legal tech company that has essentially nationalized the small claim system in the country, allowing a technological solution to getting back small debts. So I've worked as an attorney for 14 years for small and middle-sized businesses. And I teach law as well. I teach contracts, business associations, evidence, mediation, and recently have begun teaching artificial intelligence and the law, which is quite interesting. And as I mentioned, I run Squabble full-time. Okay, so today's an important topic. Consider this a public service announcement. It's something that's near and dear to my heart as somebody who respects small business owners, middle-sized business owners, grew up around them, advocated for them for 14 years, and now running Squabble. I can understand the headache associated with having a significant number of accounts receivable, customers who don't pay, debts that are outstanding. I'm calling it leakage. This is leakage from your business that you would prefer not to build into your financial model. And these are some, we're going to discuss today some ways to get to clog that leakage, to clog that hole, right? To plug that hole and to get back what you're owed. So what are some common reasons why folks don't pay, right? Well, number one, it could be a low priority, right? Obviously, they might just have more pressing, important bills or debts to cover, right? If they're trying to keep the lights on or pay rent, they're going to choose to pay those prior to paying your debt, of course. Perhaps they feel there are no repercussions, right? Maybe you've been a little bit too lenient in the past, allowing late payments. And some customers may be taking advantage of that kindness. Maybe it's just simply difficult times in their business or individually, and they're having trouble meeting your payment deadline as you originally scheduled. Other reasons, maybe are you still using paper invoices? E-payments are obviously quicker. A lot of companies are still using dead wood. So, if you're using paper invoicing, that is a way to result in a delayed processing, a delayed billing, and it affects the time frame in which you're going to receive your payments, obviously. Are you extending credit? Extending payment terms and offering credit to customers. Obviously, this is a great way to strengthen the customer relationship, but as a result, you're running a greater risk of non-payment. A customer may simply just be unhappy, right? And if you don't require payment up front, the client's just simply going to decide, hey, I'm not going to pay for this service, or I'm not going to pay for this product because I'm deciding that it failed to meet my expectations. So, we all know the common reasons why folks don't pay. So what can we do ahead of time, at least, to prevent this from occurring? We have some practical steps that we can take. So obviously you want to research your new business prospects to the best of your ability. Who are you contracting with, right? If possible, ensure that you're interacting with solvent clients rather than insolvent clients, clients with financial security, of course. Number two, be very clear with your payment policies, right? Be upfront in any agreements you have. Make sure to check your agreements. What document are you handing to customers, or documents are you handing to customers? Are they legible? Are they comprehensible? What terms are in those agreements at the point of the transaction, right? Maybe an initial line in the areas of particular importance that you really want to call attention to with regards to payment terms. Send invoices immediately, schedule reminders, ideally digital invoices with reminders. Make sure you're moving toward accepting payments online and getting automated payments set up, ideally, so that you'll have to, you're reducing as many barriers as possible to payment, and to receiving payment, as many barriers as possible that your customer is going to have to actually initiate payment. Set up a payment plan, right? That takes the sting out of the initial payment and allows you to gain momentum on an automated payment system. So what if they don't pay, right? What do we do? I want to talk, in the first portion of this discussion about the traditional ways in which we try to get back what we're owed. You can hire a lawyer, you can hire a debt collector, you could go it alone. And in each one of those options, you have a few sub options or a chronology of efforts that you might want to take, right? So if you hire a lawyer, what are you going to hire them to do? Are you going to hire them to draft a demand letter to demand payment back and to file a case, or to file a case? Are you going to hire them to attend any court hearing that you have? If you hire a debt collector, are you going to hire a debt collector that takes a percentage of the amount collected, or are you going to simply just sell your debt for a much smaller amount and have that debt buyer go after the full amount? Are you going to go it alone? Meaning that, are you going to draft a demand letter and demand payment back? Are you going to potentially file a case in small claims court? Are you going to be the one who's attending a hearing? So I want to discuss each one of these options and talk about the relative merits or detriments, benefits, and negatives of each of them, and potentially a more modern solution that might be helpful. So we'll talk about hiring a lawyer first. So what are you going to hire a lawyer to do? Well, you can walk into a lawyer's office and ask the lawyer, hey, draft me a demand letter. A demand letter says, here's how much I'm owed, and here's why I'm owed it. And if you don't pay me by such and such date, then I'm going to sue you in small claims court. You can hire a lawyer to do that. Number one, you can hire a lawyer to do that, plus put in the envelope an unfiled court pleading, so that you'll have the lawyer fill out court documents, small claims court documents. And so the person who owes you money will receive a demand letter, and they'll also receive court documents that are not yet filed, right? Sort of the specter of a lawsuit. Or the third option is you could hire the lawyer to send a demand letter, send that unfiled set of court documents, and then actually have the lawyer file in small claims court. So any and all of these options are available to you, depending upon the situation. What if you hire your lawyer to simply draft a demand letter? Should you do this? Should you go to a lawyer and say, I'm going to pay you $400, $800, $1,200, $500 to draft me a demand letter to get my money back? Obviously, this depends on the amount of money that you're owed, and it depends on other factors as well. The positives of having a lawyer draft a demand letter is it's a good first step. It shows you're serious about getting your debt back. And indeed, it's often required. A demand letter is often required in a lawsuit. You have to show that you first made a written attempt to get the money back. So that's a positive. A downside is that it's pricey to have a lawyer draft this, especially depending upon the amount of your dispute. And the likelihood of success of getting your money back simply from sending a demand letter is relatively low. If they're not paying in the first place, simply receiving a letter, even if it's from a lawyer, they're not likely to change their tune too much without any further indication that you're actually going to be suing. Statistics show that people are ignoring lawyers way more than they used to. So what else can you hire a lawyer to do? Well, maybe you hire a lawyer to draft that same demand letter and put the unfiled court pleading in the envelope as well. So the lawyer is going to send off a demand letter saying, this is how much you're owed, and you will be sued on such and such date. And by the way, here's what's attached. Here's this unfiled court pleading document. This is great because it looks official. It's official court documents. It provides the specter of a lawsuit. This is a tactic that's used quite often in larger civil litigation, in larger lawsuits for hundreds of thousands of dollars and millions of dollars, where a lawyer will send the demand letter and they'll send the prepared documents, but they haven't yet been filed with the court. So that's a good thing because you don't actually have to initiate a lawsuit, but you are amping up the pressure of the potential of a lawsuit. The downside here is that it begins to get pricey with a lawyer to have them drafting a demand letter and fill out your documents for you, especially considering that this can typically be done on your own. And statistics again show that demand letters alone don't work, even though adding an unfiled court pleading to it can help. You can still go this alone, and we'll talk about that a little bit in the coming minutes. What else can you hire a lawyer to do? You can hire a lawyer to do the full package, right? Again, this is depending upon the amount of your debt that's outstanding. You can hire them to draft that demand letter, file it, send that unfiled court pleading to the defendant, and then you can have them sue for you in small claims court, right? That's the full package. It'll probably go a long way in getting back your debt. And you are likely to be able to get some amount of attorney's fees back in any judgment that you get in small claims court, depending upon the jurisdiction. So those are some positives of this sort of troika here. The downside is that this is going to start getting super pricey, and really none of this again requires a lawyer's attention. Many lawyers won't take on small claims cases, and in many jurisdictions, they're not actually allowed if you're an individual suing, but they will be allowed if you're a business. If a lawyer does decide to take on your small claims case in this situation, they might be a newbie lawyer, which you'll have varying amounts of success with. So traditional means of collection, we had just discussed hiring a lawyer to do 1, 2, or 3 things. So those are your options there. What is another traditional means of collection? Give the debt to a debt collector. I just want to give a couple, key definitions here. This is not rocket science, but I want to lay out the basics of how we can get our debt back, right? There are ways, and it's not quite as onerous as we might think if we're organized about it. So the second traditional way that people have typically tried to get their debt back is through a debt collector, either through a debt collection agency or a debt collector themselves. A debt collection agency is a middleman, essentially, right? They're a company that collects a customer's delinquent debts, debts that are more than 60 days past due. And then once they collect them, they'll give them back to the original creditor, which would be you, the business owner. A debt collector could either work for themselves or they could work on behalf of a debt collection agency. And some of these debt collectors are also lawyers. How do they work? Well, debt collectors collect any various types of debts, right? They could collect unpaid business or personal loans, any goods you sold on account, any unpaid business invoices, any debts on contracts that were supposed to be paid out, any damages to your person or to your property, any shoddy service that you received and you think you're owed a sum of money back, you can send to a debt collection agency. So a particular agency might specialize in a type of delinquent debt, right? So maybe they say, we only collect debts that are at least $500 and 2 or more years old. Be careful when scouting out a debt collection agency. If a debt collection agency tells you that they'll collect a debt and your debt is beyond the state statute of limitations, then that is not a reputable debt collection company. And that's a good sign that you should not be working with them. The state statute of limitations is the time period that you have to file your lawsuit with the state. So if you're beyond that time period and a debt collection agency is willing to collect it after that time, they're less than scrupulous. It's best to not work with that particular agency. What do debt collection agencies do? They get paid a percentage by you, the creditor. So they're going to take anywhere from 35 to 60% of the amount that they collect. And you might be willing to do that because you're having a difficult time collecting your debt. They may sometimes negotiate settlements with your debtor for less than the amount that's owed, and that's something that an agency might offer, and you want to ask them about that when interacting with them if you want to engage a debt collection agency to get back your debt. Sometimes they might refer cases to lawyers, and then the lawyer again might file a lawsuit on your behalf, or they might file it on behalf of the debt collection agency, depending upon the arrangement. So what does a debt collector do? Well, they do what we were trying to do, right? But with what our business was trying to do. This is all prior to initiating a lawsuit. What does a debt collector do? They're going to call the person who owes you money. They're going to call the business who owes you money. They're going to send them letters. They're going to try to convince them to pay. If they can't reach them, they're going to do further searches, use software, use private investigators. They're going to conduct searches of their assets, look to their bank accounts, determine does this person or this business have the ability to repay. They can have an internal policy as a debt collector of reporting that delinquent debt to consumer credit bureaus, business credit bureaus, and that's a way of encouraging customers to pay, obviously, because a delinquent debt can clearly damage your credit score. But in this case, we are not we are prior to a lawsuit being filed, right? There's no legal action being initiated when working with a debt collector at this stage. So a debt collector has to rely on a debtor's voluntary payment, right? The debt collector cannot seize their paycheck. They can't reach into the debtor's bank account, right? Even if they know their bank account information, unless a judgment from a court is obtained, the debt collector cannot reach into their assets. A judgment must be obtained in order for us to gain leverage over the assets of the person who owes you money. And that's a court order, an order by the court requiring the other party to pay a particular amount. A collection agency can't do that unless they file a lawsuit prior to the statute of limitations running out and winning a judgment. And they actually have to have the right to file a lawsuit to do so on your behalf, which is another issue altogether. So their debt collectors' efforts are limited prior to initiating any legal action. Once a judgment is won, let's say the debt collector did file a lawsuit, whether this is you or the debt collector that you've hired, once a judgment is won in court, then there's a lot sharper teeth, right? So in this case, the debt collector would contact any delinquent debtor and remind them of a duty to pay. If the defendant who has lost a judgment won't voluntarily pay, so now the debt collector has things that they're able to do, right? They can garnish the wages of the person who owes you money. They can garnish bank accounts. They can put levies on bank accounts. They can put levies on personal property, such as motor vehicles. They can put a property lien on real property. They can potentially sometimes force the sale of an asset. So having a judgment is a valuable tool, obviously, to be able to collect from a debt collector's standpoint. You could also go with a debt buying agency. So if you think you're unlikely to collect, you could just simply sell your debt. This is sort of cutting your losses, selling your debt to a debt buyer, essentially. Creditors, in this case, they can package many accounts together that have similar features, sell them as a group, and a debt buyer would buy a package, right? So a debt buyer could choose from a package that's relatively new with no other third-party collection activity. They could be very old accounts that other debt collectors have failed to collect on. They could be accounts that fall somewhere between. But in either case, debt buyers are paying a very small amount compared to the amount of the debt. They'll pay somewhere around 4 cents for every dollar of the face value of the debt. So for instance, if your business is owed $1,000, a debt buyer might buy that debt for $40. And now that debt buyer owns the debt. So if they collect on it, it's all theirs. And you are left with the $40. So you have, you're risking the ability to get the debt back, but you are getting some bird in hand by getting some amount up front. The type of debt usually influences the price that a debt buying agency will pay. B2B debt, business to business debt, is typically worth more. But again, debt buyers, they keep everything they collect, right? They took the risk of buying the debt from you, giving your business cash, and paying in advance. So that debt becomes theirs to collect upon. And if they get the entire amount, then that is theirs to keep. In terms of debt collectors, generally speaking, general knowledge, how are you allowed to collect the debt? It's okay to call them. It's okay to email them. It's okay to send them an email, but it is not okay to contact them at work or past the hours of 9 p.m. at night or before 8 a.m. in the morning. Can a debt collector take money from your debtor's paycheck? Again, cannot take money from a debtor's paycheck unless there's an authorization to garnish wages, and that has to come through a court order. So you have to get a judgment in order to take money out of their paycheck or out of their bank account or get a lien on their property. So those are some limitations prior to getting a judgment. So hiring a lawyer or hiring a debt collector or debt collection agency, those are two traditional means of collection. What's another traditional means of collection? Well, suing on your own in small claims court, right? And you're going to have the same three options that a lawyer did. What were those? Send a demand letter, number one. Send a demand letter with that filled out court paperwork, but not yet filed. Or send a demand letter with that unfiled court paperwork, wait to see if they pay you. And then if they don't, then you can actually file in small claims court. So you can do these things on your own, and it is not terribly onerous if you figure out the appropriate way to do it. So let's get into a little bit of depth about how to do this on your own. This is, again, a traditional way that people go about collecting a sum that they rightfully think is theirs in good faith. So first thing you want to do to get your money back as your business, let's say you're not hiring a lawyer, you're not hiring a debt collection agency, write them a demand letter. This is the first step in collecting what you're owed. What are you going to put in this demand letter? Pretty basic. Put a brief history of the dispute, explain what happened, explain why there's been no agreement so far. In other words, why you're now thinking about handling it in court and what efforts you've made to collect already. Put a specific amount in there that you will be suing for, or the specific relief that you're seeking, and explain how you calculated it. Explain what you want. Put a clear, underlined, firm demand for what you want, and then always put in, hey, here's my next step if you don't pay. Here's how this will be resolved if you don't pay, which typically means I will be filing a small claims lawsuit by such and such date. Don't be threatening. Avoid overly threatening language. Don't disparage the other person. Be polite. Why? Because, that's what it takes to be a decent person. But also, the same judge who's going to hear your case is going to be reading that demand letter. So be careful to be professional in your language. Be concise. You don't want to write a dissertation here. Shorter is better. Just detailed enough to convey the details that we've previously discussed. Just long enough to clarify your intent. Make several copies of it. Keep several copies of it. Obviously, you're going to send one to the potential defendant, and then you're going to keep several copies for later for future court appearances. What if they don't respond? Then they're usually not going to. So here's where you sue. And suing is not as scary as you think it is in small claims court. I'm just going to give you the steps as to how to do it. It's relatively basic. This varies by jurisdiction, but the steps are relatively uniform throughout the country. First thing you got to do is pick your jurisdiction and venue. Legal words, but really not that complex. Jurisdiction is just the state that you're suing in, and the county that you're suing in, and sometimes the municipality, town or city that you're suing in. Venue is the particular courthouse that you're suing in. So you've got to pick the right jurisdiction and venue that's going to house your case. In most jurisdictions, but not all, the place that you're going to file your documents is going to be the place where the defendant resides, or where a large part of the events giving rise to the dispute occurred. If you're not totally clear on where your jurisdiction and venue is, go to the Where Do I File section on the court's website, or just call the clerk, ask for the small claims clerk at the courthouse. So once you've determined where you're filing, which is jurisdiction and venue, make sure to get the right forms. So you can either go to the courthouse, pick up the appropriate forms, or just print them out off of the court's website. What are you seeking? You're seeking the complaint. That's the form that starts the lawsuit. And you're seeking a summons. A summons is the document that gets filed with the complaint that gets handed to the defendant and requires them to appear in court. So a complaint and a summons are the two main documents that you're going to need, and it's going to depend upon the jurisdiction whether there's another document or two that you might have to include, such as a cover sheet. Different jurisdictions and different venues have different forms. Again, small claims is county-based typically, sometimes city or town-based. Several states do have different forms that apply to different courts. Some states have forms that are uniform throughout the state. Most of the time, it's county-based. Sometimes the forms will vary based on the type of dispute that you have. Let's say if you're suing on a breach of contract or a sale of goods on account, or an injury case. And so that's possible as well. If you're unsure, call the courthouse and ask for the small claims clerk. Usually they're pretty kind. Step 3, once you've gotten the paperwork, fill them out properly. Okay, so if you're suing another business, you got to make sure that you're suing their formal legal name. It has to be exact, right? So we can't use a trade name. And this is sometimes a headache for folks when they sue the name of the business that they were dealing with, but it's not actually the formal legal name. So obtain their exact legal name. And where do you get that? You get that from the state Secretary of State website. Just type in your state name into Google and write Secretary of State, and then go to business search and type in the business's name. There you'll find the formal legal name of the business, and you'll also find what's called their registered agent for service of process. Every business, when they incorporate in a state, has to list a registered agent for service of process, which is just the designated person that you hand the legal paperwork to if a business has been sued. So we, as a party that's suing them, has to obtain we must obtain their formal legal name and their registered agent for service of process's name. In most jurisdictions, you're allowed to add your filing and service costs to your claim. When you're filling out the forms, there's no need to over-argue your case in your complaint. You're not arguing your case in the complaint document. Let's be clear, judges are very unlikely to read these small claims forms before you even get to court, let alone the clerk reading them. They're just going to scan them briefly. So just briefly describe the events of what happened. There's no need to go into a tremendous amount of depth. You're going to argue your case later in court. If necessary, if you need further help, some jurisdictions have a small claims advisor that can help you to ensure that you're filling out the forms properly. And some local law schools have small claims clinics that can help you out as well. So once the forms are filled out properly, make sure that you file the documents in the appropriate courthouse. So you walk into the courthouse, go to the small claims business office, and hand the paperwork to the clerk, pay the appropriate filing fee, whether that's a money order or a check. You can also do this by mailing the same to the small claims clerk in the appropriate jurisdiction and venue. And then you're going to be waiting to get your stamped copies back. So if you hand it in person, the clerk will stamp your copies right there if the documents are conforming or appropriate. If you mail them in, then you're waiting for your conformed copies. That's what you want back from the court. Basically, you're getting back your complaint and your summons and any other documents that you handed in, stamped with the clerk's seal. While waiting for your conformed copy, you can check the state website, the court's website, under what's called a register of actions, to see if there's any updates regarding your case. Basically, to see, has your case been accepted yet? When you get the conformed copy back, it's just going to have your case number on it. And in some jurisdictions, this is the point at which they'll give you your court date and time of your hearing and your location. This conformed copy, the stamped copy of these documents, is the set of documents that you're now going to serve upon the defendant. Service of process. This is a required step. It's required by the United States Constitution. Even though that sounds like a big deal, the process is pretty simple. You have to have a third party hand the documents to the defendant. So state service of process rules, state civil procedure rules, and the US Constitution just simply require that not you, but a third party, whether it's a friend or the county sheriff or a professional process server, hand the documents, the conformed stamped documents, to the defendant. And you have to make sure to comply with state service of process rules, because if the way that they were handed to the defendant or the paperwork itself is deficient in any way, then the court's not going to hear your case. They might dismiss it, or they might continue out your hearing and delay the process. So it's best usually to choose a reputable service of process company to do this for around $100. Again, you can ask for these costs back in your suit from the judge. So once you've served process upon the defendant, it's essential that proof of service be filed with the court. So a process server or your friend or the sheriff gave formal notice to the defendant of the lawsuit, right? The proof of that has to be shown to the court. So a proof of service is a form that's filled out and filed by the process server. It contains information about the case and about the details of how the service of process was carried out. And then the process server signs it and files it with the court. So if you ask your friend to do service of process, you got to make sure that they sign and send in the proof of service to the appropriate court. A process server will do this for you, ensuring that the proof of service form is mailed to the appropriate court. Again, if the court doesn't receive a properly completed proof of service, it's not going to hear your case. So this is an important step in the process. Prepare for your hearing then, right? So at this point, you want to research the theory of your case, right? So your court hearing is coming up, right? What is the theory of your case? Is it a breach of contract case, right? Did someone break a promise to you in a written contract or an oral contract? Or is it a negligence case where you've been injured or your property's been injured because someone acted unreasonably? What's the theory, right? In preparing for your hearing, you'll want to make sure that you dress up a little bit, look professional. Judges like it when you respect their house. And of course, you're going to be bringing your evidence with you to the courthouse. Any supporting documents, contracts, texts, photos, videos, even a credible witness, if you have one, anything that supports the allegations that you made in your complaint. A lot of jurisdictions now are having Zoom hearings, online hearings, and they require you to submit evidence digitally ahead of time. So you'll want to pay close attention to your conformed copies for instructions about how to submit your evidence prior to your hearing. To prepare for your hearing, if you have a breach of contract case, which is mostly what the types of disputes that businesses will have, you got to show three things when you go to court. You got to show that there's a valid enforceable contract, right? So you want to prepare copies when you're going to court of a formal agreement or any other indication of the agreement in writing. So emails, texts, audio, video recordings, anything that demonstrates that you had a valid contract. You want to show that the other side breached that contract by either not performing at all or performing in some substandard way, either performing improperly or not fully paying or not paying at all. And then you must demonstrate that a remedy is appropriate. So you want to itemize with precision why you're owed the amount that you're seeking. Remember to add your costs to your your argument in court, because you can convince the court to get back your filing fees if you happen to have hired an attorney, any fees you paid for service of process. Add your cost there, and you also want to add interest. You're entitled to interest, what's called prejudgment interest, which allows you to collect money on the amount of money that you would have had. You should have been paid from the date that you were injured until the date that you're actually paid. So you're entitled to interest on that money as well. Obviously, you're going to watch out for defenses that the defendant is going to have as well in a breach of contract case. If it's a negligence case, this is a case where the defendant acted unreasonably and injured your person or injured your property. You're going to have to show four things. Show the defendant owed you a duty or owed your business a duty. Show the defendant breached that duty, meaning they fell below the standard of care or they failed to act reasonably as the reasonably prudent other party would have, that their action caused your injury and that you experienced damages, some measurable harm that you injured. And again, there will be defenses that the defendant can present, such as contributory negligence, where they're saying that you contributed somehow to the harm, or you, the plaintiff, assumed some risk of taking on that harm. So you can do a little bit of prep before your hearing. When you attend your hearing, a few quick tips for you to know. Wait your turn, be respectful, call the judge your honor. Explain what happened and do so in a calm way, in a succinct way. Get right to the pertinent facts, get to your point quickly. These are very brief hearings. There's not a lot of patience there. So if you're going in a roundabout direction, you might miss the opportunity to get to what you actually want to say. Avoid any complicated law. Understand the elements of your case in the way that I laid out briefly in the previous slide. Calmly explain why those elements are met. And if you're not familiar with the area of the law, that's okay. Just explain the facts of what happened, and that's fine. This is going to last all of 5 minutes. You're going to get a judgment right there, or you're not. 50% of defendants don't show up. And if they don't, you get a default judgment, which is nice. Step 10, get ready to collect. So you're going to first try to obtain a voluntary payment from the debtor. And if they don't pay, research what income or assets the debtor has that could be used to pay your judgment, like through an asset search company or a private investigator. And again, if they don't pay, you'll have the same means of collection that an attorney or a debt collector would have. Once you get your judgment, you're now able to place a bank levy, get a property lien, garnish their wages, threaten professional license suspension, and report the debt to a credit agency. So those would be the 10 steps of going it alone. So those are some of the traditional means overall that people have typically used to try to get their money back, right? Hiring a lawyer to do this, hiring a debt collector, or going it alone. Are there any easier, slightly more modern options that we have now? Thankfully, yes. The headache is soon and is fastly becoming a thing of the past. So on modern dispute resolution platforms, you're able to essentially answer basic bubbly questions about your case, pay the state filing fee, pay a service process fee, pay the company's fee, and then you're essentially done. The platforms might be able to, depending upon what the platform is, they might be able to do a series of things for you. They could calculate your jurisdiction and venue for you. They can calculate the monetary limits of small claims in your jurisdiction, calculate the statute of limitations. They could check the submission of your legal documents for legal and administrative compliance. They can actually file your claim in the appropriate jurisdiction and courthouse. They can monitor your claim for acceptance. They can get you your case number and your date and the time of your hearing and send you reminders. They can carry out service of process for you upon the defendant. And they can provide all of your court documents and updates throughout the process all the way through your hearing and give you court prep tips, with some platforms even now beginning to introduce the prospect of it being able to mediate and resolve the dispute on the platform, hopefully without the need for litigation. If your business has a dispute over the small claims limit for your jurisdiction, usually, by the way, small claims limits are, it depends on the county, depends on the state, anywhere from 3,000 to 25,000 and everywhere in between. If you have a dispute that's greater than the small claims limit, you could either agree to waive that amount and sue for the maximum, or if you think it's appropriate, then it might be become time to engage the services of a lawyer. Feel free to fire away with any questions that you have. I am available at meganthal@squabbleapp.com. Squabble is the name of my company. Squabbleapp.com is our website. I'm passionate about protection of and growth of small and middle-sized businesses, and have a lot of respect for people who are doing so. So I try to make myself available for any and all questions, and here's where you can contact me.
Well, thank you, Michael. That was very complete and thorough and excellent. We do have one question already in the portal. Please add your questions to Q&A on any topic, and we've got plenty of time to answer them for you. Michael, can you read that? It might be better if you read it. I can read it to you, but if you can look at it.
Where would I see that, Doug?
The Q&A. Can you see
Should
the
I
Q&A?
stop my share?
Oh, no. You should be able to see it with that. I'll read it to you.
Okay.
What if you went into a contract agreement with a person who is protected by privacy laws? When we get to court, it is allowable to breach client confidentiality in pursuit of the debt, such as failure to pay a copay, deductible, or coinsurance.
Right. So that is a legal question that I'm not allowed to exercise any judgment on in a public forum like this. But if you want to email me, I can provide some guidance for you. We're subject to strict ethical guidelines in terms of forming attorney-client relationships. So you'd want to consult with an attorney on that one.
Other questions for Michael? Here's your chance. Again, you will be getting a copy of the recorded webinar, plus you get all the slides, tons of information on those slides. They'll be available to you probably later today or tomorrow. Be sent to you individually, and then it'll be on our website as well and on YouTube. Any other questions? Okay, let me remind you to visit score.org/Minnesota to request a mentor. You can also email Michael as he's giving you his information and information about Squabble. And with that, we will conclude our webinar. Thanks again, Michael.
Thank you, guys.